This is current as of May 2017. California Commercial Driver's Handbook Audio Edition, starting at Introduction 1.2. This is one of the best ways to learn, better than the electronic voice that you can find on YouTube. 1.2. Medical Documentation Requirements. When you are applying for a California Department driver's license permit, or are renewing, upgrading, adding endorsements to, or transferring a CDL from another state, you are required to provide information regarding the type of commercial motor vehicle operation you drive in or expect to drive in with your CDL. Drivers operating in certain types of commercial will be required to submit a current medical examination certificate or any medical variant document that you have been issued. Example, vision, skills, performance, or diabetic waivers, or other exemptions. Now, to obtain a certified medical status as part of your driving record, you must contact your local DMV office to obtain information regarding the requirement for submitting these documents. If you are required to have a certified medical status and fail to provide and keep up to date your medical examiner certificate, you become, quote, not certified, and you may lose your driver's license. Now, for the purpose of complying with the requirements for medical certification, it is important to know how you are using your commercial motor vehicle. The following information will help you decide how to self-certify. Interstate or intrastate commerce. So that's interstate or intrastate. Do you or will you use your CDL to operate a vehicle in interstate or in intrastate commerce? That's a question. Interstate commerce is when you drive a vehicle from one state to another state or to another country, or between two places within a state, but during part of the trip the vehicle crosses into another state or country, or between two places within a state, but the cargo or passengers are part of a trip that began or will end in another state or country. Now, intrastate is when you drive a vehicle within a state and you do not meet any descriptions above for interstate commerce. So intrastate is in the state. If you operate in both intrastate and interstate, you must choose interstate commerce. Now, inter and intra-commerce status, not accepted or accepted. California does not issue a California driver's license that is exempted from driver qualification requirements. Okay, section 1.2.3, self-certification statements. When completing an application for your CDL, you will be required to check the box next to the statement that describes your status. The actual statements on your application vary from those shown below. Interstate, non-accepted. I certify that I operate or expect to operate in interstate commerce, that I am subject to and meet the federal DOT medical card requirements under CFR Title 49, Part 391, and that I am required to obtain a medical examiner certificate. Now, interstate accepted. California does not issue a CDL that is accepted from driver's qualification requirements. Next, intrastate non-accepted. I certify that I operate or expect to operate entirely in intrastate commerce, that I am subject to and meet the medical requirements for my state, and that I am required to obtain a medical examiner's certificate. Now, intrastate accepted. California does not issue a CDL that is accepted from driver's qualification requirements. Okay, section 1.3, CDL disqualifications. 1.3.1, general. You may not drive a commercial motor vehicle if you are disqualified for any reason. 1.3.2, alcohol, leaving the scene of an accident and commission of a felony. It is illegal to operate a commercial motor vehicle if your Blood alcohol level is 0.04% or more. If you operate a commercial motor vehicle, you shall be deemed to have given your consent of alcohol testing. You will lose your CDL for at least 1 year for a first offense for driving with your alcohol level of 0.04% or higher, driving a vehicle under the influence of alcohol, refusing to undergo blood test, driving a vehicle while under the influence of a controlled substance, leaving the scene of an accident, committing a felony involving the vehicle, driving the vehicle when the CDL is suspended or revoked, causing a fatality through negligent operation of the vehicle. Yes, we have covered this section in the last video, but we just wanted to cover it again because it is very important. It's almost over. Now, you will lose your CDL for at least 3 years if the offense occurs while you are operating a vehicle that is placarded for hazardous materials. You will lose your CDL for life for a second offense, and you will lose your CDL for life if you use a commercial motor vehicle to commit a felony involving a controlled substance. You will be put out of service for 24 hours if you have any detectable amount of alcohol in your blood. Now, 1.3.3 Serious Traffic Violations. Serious traffic violations are excessive speeding, 15 miles per hour or more above the posted limit. Now, reckless driving, improper or erratic lane changes, following a vehicle too closely, traffic offenses committed in a commercial motor vehicle in connection with a fatal traffic accident, driving a commercial motor vehicle without obtaining a CDL or having a CDL in the driver's possession, and driving a CMV, which is commercial motor vehicle, without the proper class of CDL. Now, you will lose your CDL for at least 60 days for 2 serious traffic violations within a 3-year period, or at least 120 days for 3 or more serious traffic violations within a 3-year period. Now, section 1.3.4, violations of out-of-service orders. Now, you will lose your CDL for at least 90 days for your first violation of an out-of-service order, or at least 1 year if you have committed 2 violations of an out-of-service order in a 10-year period, or at least 3 years for 3 or more violations of an out-of-service order in a 10-year period. 1.3.5 Railroad highway grade crossing violations. You will lose your CDL for at least 60 days for your first violation, or at least 120 days for your second violation within a 3-year period, or at least 1 year for your third violation within a 3-year period. These violations include violations of federal, state, or local law or regulations pertaining to one of the following 6 offenses at a railroad crossing. 1. Now, if you're a driver and you're not required to stop at the tracks, but you fail to stop before reaching the crossing if the tracks are not clear, or failing to slow down and check that the tracks are clear of an approaching train. So you got to slow down, and if the tracks aren't clear, you need to stop. Okay, now for drivers who are required to always stop at the train tracks, but they fail to stop before driving into the crossing, big trouble, or failing to have sufficient space to completely drive through the crossing without stopping, or failing to obey a traffic control device or an enforcement officer at the tracks, or failing to negotiate a crossing because of insufficient undercarriage clearance. 1.3.6 Hazardous materials endorsement, background check, and disqualification. If you require a hazardous materials endorsement, you will be required to submit your fingerprints and be subject to a background check. You will be denied or lose your hazardous materials endorsement if you are not a lawful resident of the United States, or renounce your citizenship, or are wanted or under indictment for certain felonies, or if you have a conviction in military or civilian court for certain felonies, or you have been adjudicated as a mental defective or committed a mental institution, or are considered to pose a security threat as determined by the TSA. Now, for more information, go online to universalenroll.dhs.gov or call 1-855-347-8371. 1.3.7 Traffic violations in your personal vehicle. The Motor Carrier Safety Improvement Act of 1999 requires a CDL holder to be disqualified from operating a commercial vehicle, if the CDL holder has been convicted of certain types of moving violations in their personal vehicle. If your privilege to operate your personal vehicle is revoked, canceled, or suspended due to violations of traffic laws, other than a parking violation, you will also lose your CDL privileges. If your privileges to operate your personal vehicle is revoked, canceled, or suspended due to alcohol or drugs or felonies, you will lose your CDL for 1 year. If you are convicted of a second violation in your personal vehicle, your commercial vehicle will lose your CDL for life. Now, if your license to operate your personal vehicle is revoked, canceled, or suspended, you may not obtain a hardship license to operate a commercial vehicle. 1.3.8 Violation point counts. Convictions that occur while you are driving a CMV or CDL holder are retained on your driving record as listed below. Now, major violations and disqualification actions, 55 years. Out-of-service violations and disqualification actions, 15 years. Accidents, serious violations, and disqualification actions, 10 years. Railroad grade crossings and disqualification actions, 4 years. Minor convictions, 3 years. A traffic accident for driving unsafely counts as 1 point. Any accidents you contribute to or were responsible or at fault for are normally counted as 1 point. If you are convicted of reckless driving, driving under the influence of alcohol or drugs, or a hit and run, you are charged 2 points. You will lose your privilege to drive if you are considered a negligent operator of a commercial vehicle. When your driving record shows the following point counts: 4 points in 12 months, 6 points in 24 months, 8 points in 36 months. Don't get any points. Now, you may be entitled to a higher point count, 6, 8, or 10 points, if you request and appear for a hearing and a 4, 6, or 8 points were not obtained in a Class C vehicle. A violation received in a commercial vehicle carries 1.5 times the point count. A-Class, A or B drivers who does not have a special certificate or an endorsement may be allowed 2 additional points before being considered a negligent operator. Convictions reported by other states are added to your driving record and may result in license sanctions. If you have an out-of-state CDL, any conviction while operating in California will be reported to your home state. Note: when a commercial driver is cited in a non-commercial vehicle, the driver may be eligible to attend traffic school. 1.3.9 Violations of hands-free or texting. Cell phones while driving. Listen up. Regardless of what type of vehicle you are in at the time of a violation, you will lose your CDL. For at least 60 days for your second violation of the cell phone hands-free or texting law, within a 3-year period, and receive 1 point on your driving record. Or for at least 120 days for your third violation of the cell phone hands-free texting law within a 3-year period and receive 1 point on your driving record. 1.4 Other CDL rules. There are other federal and state rules that affect your driving, operating of a commercial vehicle in all states, and among them are these. Be a California resident before applying for a California driver's license. Disclose all states which you were previously licensed during the past 10 years and surrender all out-of-state driver's license, even if they're expired. You cannot have more than one driver's license. If you break this rule, a court may fine you up to $5,000 or put you in jail and keep your home state license and return any others. You must notify your employer within 30 days of conviction of any traffic violations. Now, this is true no matter what type of vehicle you're driving. You must notify your motor vehicle licensing agency within 30 days if you are convicted in any jurisdiction for any traffic violation, well, except parking. Now, this is true no matter what vehicle you're driving. You must notify your employer within 2 business days if your license is suspended, revoked, or canceled, or if you disqualified from driving. You must give your employer information on all driving jobs you have held in the last 10 years. You must do this when you apply for a commercial driving job. No one can drive a commercial motor vehicle without a CDL. A court may fine you up to $5,000 or put you in jail for breaking this rule. Now, if you have a hazardous materials endorsement, you must notify and surrender your hazmat endorsement to the state that issued your CDL within 24 hours of any conviction, civilian or military. Any conviction in which you were found not guilty by reason of insanity or disqualifying crime listed in the CFR titled 49-1572.103, who is adjudicated as a mental defective or committed of a mental institution as specified in CFR title 49-1572.109, or who renounces his or her United States citizenship. Now, your employer may not let you drive a commercial vehicle if you have more than one license or if your CDL is suspended or revoked. A court may fine the employer up to $5,000 or put him or her in jail for breaking the rule. All states are connected to one computerized system to share information about your CDL driver's license. The states will check on drivers' history records to be sure that the drivers do not have more than one CDL. You are not allowed to hold a mobile telephone to conduct a voice communications or dial a mobile telephone by pressing more than a single button while driving. You are not allowed to send or read text messages while driving. You must be properly restrained by a safety belt at all times while operating a commercial vehicle. The safety belt designs holds the driver securely behind the wheel during an accident, helps the driver control the vehicle, and reduces the chances of serious injury or death. If you do not wear a safety belt, you are 4 times more likely to be fatally injured if you are thrown from the vehicle. 1.4.1 State Laws and Rules. All commercial drivers must know the state laws limiting the size and weight of the vehicles and loads. All commercial vehicles must stop at locations posted for CHP testing and inspection. Any officer who has reason to believe that a commercial vehicle is not safely loaded, or the height, width, length, or weight of the vehicle's load is unlawful, is authorized to require the driver to stop and submit an inspection measurement or weighing the vehicle. The officer may have the driver stop in a suitable area and reload or remove any part of the load. Any person driving a commercial vehicle over a highway or bridge illegally is liable for all damage caused to the highway or bridge. Now, when the driver is not the owner of the vehicle but is operating it with the permission of the owner and driver may both have to pay the damage. Now let's talk about state air emissions rules, the emission rules in California. All commercial diesel vehicles and equipment that operate in California, even those based out of state or out of country, are subject to the emission requirements as specified by the Air Resource Board. To enforce these requirements, ARB, the Air Resource Board, is authorized to inspect all vehicles and equipment for excessive smoke, tampering, and compliance with fleet rules and issue citations with substantial penalties for non-compliance. Commercial diesel vehicle inspections and performed by the ARB inspection team at border crossings, the CHP weigh stations, fleet facilities, and randomly selected roadside locations. Some key regulations are as follows. 1. Truck and bus regulations. The regulation applies to nearly all privately and federally owned diesel trucks and buses, to privately and publicly owned school buses with a gross vehicle weight of more than 14,000 pounds. All diesel trucks and buses that operate in California must be upgraded with a diesel particulate matter filter to reduce exhaust emissions beginning January 1, 2012. Lighter and older heavy diesel trucks must be replaced with a 2010 model year engines or equivalent starting January 1, 2015. And by January 1, 2023, nearly all trucks and buses will need to have 2010 model year engines or equivalent. The regulation does provide a variety of flexibility options tailored to fleet operating low-use vehicles and fleets operating in selected locations like agriculture and construction. Emission control label. All diesel trucks and buses with a gross vehicle weight of 6,000 pounds that have a 1974 or newer engine must have an ECL installed on the engine. A properly affixed label and legible manufacturer emission control label is required as proof that the engine meets these emission standards. Periodic Smoke Inspection Program. All owners of California-based fleets with 2 or more on-the-road diesel trucks with a gross vehicle weight of 6,000 pounds for engines 4 years and older must annually test the opacity of these vehicles and maintain test records for a minimum of at least 2 years. Commercial idling. All commercial diesel vehicles, 10,000 pounds or more, limited to 5 minutes of non-essential idling in all California areas. A commercial vehicle or school bus may not idle for any time if at school. Tractor-trailer greenhouse gas. All 2011 through 2013 model year sleeper cabs, tractors, must be SmartWay designated models. A 2014 model year or newer tractors are covered by federal regulations. All 53 feet or longer box trailers must be SmartWay certified or aerodynamically retrofitted to meet minimum standards of operation. Solid waste control vehicle. All diesel trucks, 14,000 pounds or more, and model year engines from 1960 to 2006, used to collect residential or commercial waste, must clean up the exhaust from these vehicles by using particulate matter reduction technology. Public agency and utility vehicles. All diesel vehicles with a gross vehicle weight of 14,000 pounds and a model year engine 1960 to 2007 operated by a public agency or private utility must clean up the exhaust of these vehicles by using particulate matter reduction technology. Transit bus. All public transit agencies, fleet vehicles, and urban buses, 8,500 pounds or more, upgrade equipment to meet stringent emission standards. Transport refrigeration units. All diesel-fueled TRU tractors based in California must register with the ARB label with an ARB identification number and must meet in-use standard based on the TRU engine model year. Additionally, only compliant TRUs and set for operate in California. Okay, port truck. All on-road Class 7 and Class 8 with a gross vehicle weight of 26,000 pounds. Diesel trucks that transport cargo to and from California's ports and intermodal year rail cars, regardless of the state or country of origin, must be registered with the ARB's Drayag Truck Registry and have a 2007 model year or newer engine. Note, for more information on each regulation above, visit www.arb.ca.gov/truckstop or call 1-866-6-DIESEL. Length of vehicle and loads. The single vehicle. The maximum length for a single vehicle is 40 feet. This length may exceed by parts complying with fender and mudguard provisions of the commercial vehicle. Note: some vehicles are conditionally exempted from the 40-foot maximum length, semi-trailers, buses, and house cars. The front bumper of a vehicle must not extend more than 2 feet ahead of the fenders, cab, or radiator, whichever is foremost. On a bus, a front and or rear safety bumper may extend an additional foot, and a wheelchair lift may extend up to 18 inches ahead of the bus. Additional extensions up to 36 inches in front or 10 feet in the rear of some buses may be added to transport bicycles. An articulated bus or trolley coach cannot exceed a length of 60 feet. Now, length of vehicles, combination vehicles. In a combination vehicle, auxiliary parts or equipment which do not provide space for carrying a load or are not used to supply or carry the vehicle may exceed the single vehicle length limit, but the combination may not exceed the length limit for combinations. A semi-trailer being towed by a motor truck or truck tractor may exceed 40 feet when certain conditions are met. A combination of a truck tractor and a trailer coupled together shall not exceed a total length of 65 feet, except as provided in CVC 35401 and 35401.5. A combination of vehicles consisting of a truck, tractor, semi-trailer, and trailer cannot be longer than 75 feet, providing the length of either trailer does not exceed 28 feet and 6 inches. If posted, cities and counties may prohibit a combination of vehicles in excess of 60 feet in length on highways that they control. Other exceptions can be found in CVC 35401.5. Extension devices are allowed with restrictions. The load length of any vehicle or combination vehicle may not be more than 75 feet long, measured from front of the vehicle or load to the back of the vehicle or load. Now let's talk about length exceptions. Some length exceptions are listed below. If the load consists only of poles, timbers, pipes, structural materials, or single unit component parts including missile components, aircraft assemblies, drilling equipment, and tanks not exceeding 80 feet in length, provided they are being transported on one of the following: 1. Pole or pipe dolly or other legal trailer used as a pole pipe dolly pulled by a motor vehicle. 2. Semi-trailer. 3. Semi-trailer and a pole pipe dolly pulled by a truck, tractor, or haul flexible integral structural material. Public utilities refer to CVC 35414B for load exceptions. The load on any vehicle or combination of vehicles must not exceed more than 3 feet beyond the foremost part of the front bumper or tires. There are exceptions for booms, masts of shovels and cranes, or water well drilling and surfacing equipment. A load composed solely of vehicles may extend 4 feet ahead of the front tires or front bumper. The load on any single vehicle may not extend the rear beyond the last point of the support more than 2/3 of the length of the wheelbase of the vehicle. On a semi-trailer, the wheelbase extends from the center of the last axle of the towing vehicle to the center of the last axle on the semi-trailer. Width of vehicles and loads. Let's talk about the width. The outside width of the body of the vehicle or load must not exceed 102 inches or 8.5 feet. The width of a vehicle with pneumatic tires or air-filled tires, measured from the outside of one wheel to the outside of the opposite wheel, must not exceed 108 inches, which is 9 feet. Permitted devices limited to door handles, hinges, cable cinchers, chain binders, and placard holders may extend 3 inches, 6 inches on the side for vehicles used for recreational purposes on each side of the vehicle or load. So they may extend 3 inches, chain binders, placards, etc. Required devices limited to lights, mirrors, or other devices may extend up to 10 inches on each side. Cities and counties may post signs on highways which they control to permit wider vehicles or prohibit vehicles wider than 96 inches or 8 feet. Special mobile equipment and special construction and highway maintenance equipment may not be more than 120 inches, 10 feet wide. Motor coaches or buses may be 102 inches wide when operated by common carriers for hire in urban or suburban service. They may be 104 inches wide. When a vehicle is carrying loosely piled agricultural products such as hay, straw, or leguminous plants in bulk, rather than crated, baled, boxed, or stacked, the load and racks that hold the load may be more than 120 inches wide, but a special trip permit may be obtained from the California Department of Transportation. The transport trusses and similar one-piece construction components up to 12 feet wide. Variants for farm equipment. Let's talk about farm equipment. Implements of husbandry, or farm equipment, are generally exempted from the width and length limitations if they are being operated, transported, or towed over a highway incidental to normal farming operations. Owners and operators of such equipment should refer to the CVC provisions which apply. A Caltrans transportation permit may be necessary. Okay, let's talk about the heights of the vehicle and load. The height. The vehicle height limit or load limit measured from the surface of the roadway on which the vehicle stands is 14 feet. But there are some exceptions. Exceptions: double-deck buses may not exceed 14 feet and 3 inches. Farming equipment moved incidentally over a highway has some exceptions also. Now let's talk about weight limits. Weight limits general. Caltrans has authority to post signs at bridges and along state highways stating the maximum weight they will sustain. Such weight may be greater or lesser than the maximum weight limits for a vehicle specified in the CVC code. Now, counties and cities may post higher or lower weight limit signs along the highways and bridges that they control. Alternate routes may be given for vehicles which are too heavy or posted highways and bridges. Axle weight limit. The gross weight which can be carried by the wheel of any one axle must not exceed 20,000 pounds, or 20,500 pounds for buses. Additionally, the load limit stated by the tire manufacturer shall not be exceeded. Now, this can be found on the sidewell of the tire. The weight carried by the wheel or wheels on one end of an axle must not exceed 10,500 pounds. This limitation does not apply to vehicles transporting livestock. Now, combinations of vehicles made up of a trailer or semi-trailer, and each vehicle in the combination, must meet either weight and provisions in the CVC code 35551 or following. The gross weight placed on the highway by the wheels on any one axle of a vehicle must not exceed 18,000 pounds. The gross weight on any one wheel or wheels supporting one end of an axle and resting on a roadway must not exceed 9,500 pounds. Some exceptions. The gross weight placed on a highway by the wheels on any front steering axle of a motor vehicle must not exceed 12,500 pounds. Or vehicles carrying livestock are exempt from the gross weight limit which applies to a wheel at one end of an axle. A complete listing of vehicles exempt from front axle weight limits can be found in CVC 35551.5b. The total gross weight with load placed on a highway by any two or more consecutive axles in a combination of vehicles or a vehicle in the combination, where the distance between the first and last axles of the two or more consecutive axles in an 18 feet or less must not exceed that given for the respective distance as shown in the table in CVC 35551.5C. Okay, when the distance between the first and last axles is more than 18 feet, use the table shown in CVC 3551.5D. Okay, let's talk about weight limit logs. When limits for vehicles transporting logs are contained in CVC 35552 and 35785, such additional weight may not be transported on interstate highways. Okay, weight to axle ratio. Highways and bridges are designed to carry only a certain amount of weight per foot of distance between the axles. Vehicles carrying heavy loads must not put too much weight on any one point. The limitations are shown in the tables found in CVC 3551 and 35551.5. The total gross weight in pounds placed on the highway by any two or more consecutive axles must not exceed that given for a respective distance of the table. In addition to weight specified in the previous mentioned table, two consecutive sets of tandem axles may carry a gross weight of 34,000 pounds each. If the distance between the first and last axles of the set of axles is 36 feet or more, the gross weight on each set of tandem axles must not exceed 34,000 pounds, and the gross weight on any two consecutive sets of tandem axles must not exceed 68,000 pounds. Okay, let's talk about loading and unloading. Load limits are not enforced when vehicles are loading or unloading in the immediate vicinity of a loading or unloading area. A driver moving a load under a special permit may not change the route. Exception: to avoid violating a local city traffic regulation, the driver may detour the route or non-residential streets only and return to the route as soon as possible. Okay, penalties for weight restriction violations. So, penalties for weight violations. A driver who changes from the permitted route for a load without a peace officer's authorization to do so is guilty of a misdemeanor. Okay, CHP Uniform Weight Standards. A standard for enforcing weight laws has been established by the CHP. The standard states, vehicles weighing in excess of the legal limits by 100 pounds or more shall not be permitted to proceed until the overload has been adjusted or removed. In practice, CHP will allow for a 200-pound variation factor. After applying the variation factor, any vehicle exceeding the axle weight, axle group weight, or gross weight limits by 100 pounds or more will be issued a citation and required either to adjust the load to make it legal or obtain an overweight permit before proceeding. Cargo containing hazardous materials may be allowed to proceed as loaded, provided an unloading or load adjustment cannot be handled with reasonable safety to the driver and the public. Livestock and field-loaded bulk perishable agricultural products destined for human consumption being transported from the field to the first point of processing have a special exemption. The vehicle transporting livestock and perishable agriculture products will be cited and allowed to proceed as long as the weight does not exceed legal limits by 1,000 pounds on any axle or axle group of single truck or 2,000-pound gross weight on a combination of vehicles. Permits. Let's talk about permits. Transporting an oversized load without a permit is punishable by a $500 fine or 6 months in jail or both. Also, excess load penalties may be imposed. It is against the law in California to drive or move on any street or highway any vehicle which is wider, higher, or heavier than the limits described here. Permits for oversized vehicles may be obtained from Caltrans for state highways, the city or county for city or county highways, Motor carrier permits. Let's talk about motor carrier permits. Any person who operates a commercial vehicle, either for hire or privately, must obtain a motor carrier permit. The motor carrier permit definition for a commercial vehicle is any self-propelled vehicle listed in a CVC 34500 A, B, F, G, and K, or a motor truck with 2 or more axles weighing more than 10,000 pounds, or other motor vehicles used for transport property for hire. Note: an MCP or CMV does not include vehicles operated by household good carriers, California Public Utilities Commission, or 2-axle daily rental trucks weighing less than 26,000 pounds. To obtain MCP forms and information, go to www.dmv.cav.gov or write or call the Department of Motor Vehicles. Okay, Unified Carrier Registration, or UCR. Interstate or foreign motor carriers transporting property are required to obtain UCR, as outlined in the final regulations issued by the Federal Unified Carrier Registration Act of 2005. UCR fees can be paid online at www.ucr.in.gov. Okay, here we go. Let's talk about speed limits. The maximum speed limit in California is 55 miles per hour for the following vehicles: truck or truck tractors having 3 or more axles, or vehicles pulling any other vehicle, or a school bus transporting any pupil, or a farm labor vehicle transporting passengers, or any vehicle transporting explosives, or a trailer bus. For all other vehicles, the maximum speed limit on most California highways is 65 miles per hour. However, for 2-lane undivided highways, the maximum speed limit is 55 miles per hour, unless posted for a higher speed. On some highways, the maximum speed limit is 70 miles per hour, but only if there are signs posted showing 70 miles per hour. No person shall drive at such a slow speed as to impede or block normal and reasonable movement of traffic, except when reduced speed is necessary for safe operation, for compliance with the law, or when the size of the weight of the vehicle or combination makes reduced speed unavoidable. The right lane rule. Let's talk about the right lane rule. Vehicles listed in CVC 22406 must be driven in the designated lane or lanes when signs are posted. When no signs are posted, these vehicles must be driven in the right-hand traffic lane or as close as possible to the right edge of the curb. On a divided highway with 4 or more traffic lanes in one direction, these vehicles may also be driven in the lane just to the left of the right-hand lane. When overtaking or passing another vehicle going in the same direction, drivers of such vehicles must use either 1. The designated lane, 2. The lane just to the left of the right-hand lane, or 3. The right-hand traffic lane when such is permitted. Designated system access. Designated system access does not apply to drivers who is preparing to left or right-hand turn, 2. In the process of entering or exiting a highway, or driving in a lane other than the right-hand lane to continue to the intended route. Buses, except school buses or trailer buses, may drive in any lane as long as they are not towing another vehicle. Movement off or onto designated systems or freeway or highway by larger trucks is allowed only at interchanges or exits which have the following signs. Movement is allowed along side routes to reach terminals. Terminals are located where freight is consolidated, full loads are offloaded, vehicle combinations are regularly maintained, stored, or manufactured. Movement is allowed up to 1 mile from the identified exits or entrance leading to or from specified highways to obtain food, fuel, lodging, or repairs. Okay, what about the slow vehicle rule? On a two-lane highway where passing is unsafe, a slow-moving vehicle with 5 or more vehicles behind it must turn off the roadway at the nearest place designated by signs as a turnout, or wherever sufficient area for a safe turnout exists to let the following vehicles pass. Hours of service. You are required to comply with the California's driver's hours of service regulations when you are involved in interstate commerce, or intrastate commerce, You are considered to be involved in intrastate commerce when you do not cross the state line, transport cargo which is originated from another state, transport cargo destined outside of California, transport any hazardous substance or wastes. Other rules. You are required to comply with the federal driver hours of service regulations when you are involved in interstate commerce. You are considered to be involved in interstate commerce when the cargo you transport, 1. originates outside of the state, 2. is destined out of state, 3. consists of hazardous substance or wastes, 4. any combination of the above. Here's an hours of service chart. Driving time. If you're federal or interstate, you may not drive more than 11 hours following 11 consecutive hours off duty. If you're in California only, you may not drive more than 12 hours following 10 consecutive hours off duty. Now, on-duty time. If you are federal or interstate, going out of state, you may not drive beyond the 14 hours after coming on duty following 10 hours off duty. You may perform work, except for driving, after being on duty for 14 hours. Now, if you're intrastate or only in California only, you may not drive after having been on duty for 16 hours. You may perform work, except for driving, after being on duty for 16 hours. Now, if you're going from state to state, multiple day-on duty time limitations. Okay, from state to state, you are not eligible to drive after having been on duty for 60 hours in a 70-day period, or a 7-day period. However, if a motor carrier has commercial motor vehicle operating 7 days a week, the driver is not eligible to drive after having been on duty for 70 hours in an 8-day period. The driver may restart a 7-8 consecutive day period after taking 34 or more consecutive hours off duty. Now, if you're in California only, you are not eligible to drive after having been on duty for 80 hours in an 8 consecutive day period, or if transporting farm products after having been on duty for 112 hours in a consecutive 8-day period. Now, for truck drivers, any period of 8 consecutive days may end with the beginning of an off-duty period of 34 or more consecutive hours. Okay, if you're going out of state, after driving 11 hours or being on duty for 14 hours, you may not drive again until you have had 10 consecutive hours off duty. There is an exception. If the truck is equipped with a sleeper berth, these 10 hours may be broken up into 2 periods, providing one is not less than 8 hours. So you must get 8 hours sleep. Now, if you're just in California only, after driving for 12 hours or being on duty for 16 hours, you may not drive again until you have had 10 consecutive hours off duty. Now, there is an exception. If the truck is equipped with a sleeper berth, these 10 hours may be broken up into 2 periods, provided one period is not less than 8 hours. Okay, if you're going out of the state, interstate commerce or federal, you may drive an additional 2 hours if you encounter weather conditions which were not apparent at the start of the trip. Now, if you're in California only, you may drive an additional 2 hours if you have encountered weather conditions which were not apparent at the start of the trip, regardless of the adverse conditions. If you are not drive for more than 14 hours having been on duty for 16 hours. Okay, let's talk about driver's record of duty status. The CHP is authorized to develop additional safety and driving regulations. A driver's record of duty status must be used to record all the driver's hours. Drivers of commercial vehicles must be in compliance with the hours of service required in the CFR Title 49 395.8. A driver's record of duty status is duplicate must be kept by each driver and each co-driver while driving. On duty but not driving or resting in a sleeper berth, the record of duty status must be presented for inspection immediately. Upon request by an authorized CHP employee, any regular employed or salaried police officer or deputy sheriff, there may be instances when you do not need to maintain a record of duty status. Let's talk about reporting accidents. Each driver involved in an accident which results in death, injury, or property damage over $1,000, effective January 1st, 2017, must report the accident on a report of traffic accident occurring in California form on DMV. The report forms are available at the DMV website. You or your authorized representative must submit the report within 10 days of the accident, whether you caused the accident or not, and even if the accident occurred as in private property. The SR1 is required in addition to any other report made to the police CHP or your insurance company if the accident results in damage over $1,000 and or death or injury. If you do not report the accident to the DMV, your driving privileges will be suspended. Note: CDL holders may downgrade to a non-commercial driver's license during the mandatory suspension period to be eligible to obtain restricted license. All tests and fees will be required to upgrade when eligible. California law states that you must notify your employer within 5 days if you have an accident while driving your employer's vehicle. However, your employer may require you to notify him or her immediately. Financial responsibility requirements or insurance. Motor carriers of property. Most commercial vehicles transporting property are under the regulation of the DMV, whose liability and property damage requirements are listed below. The following limits do not apply to pickup trucks as defined in CVC 471 and two-axle daily rental trucks with a gross vehicle weight less than 26,000 pounds when operated in a non-commercial use. Transporting general freight exclusively in vehicles with a gross vehicle weight of 10,000 pounds or less, $300,000 combined single limit. Transporting general freight of vehicles with a gross vehicle weight of 10,000 pounds or more, $750,000 combined single limit. Transporting petroleum products in bulk and highways, $500,000 for injury or death of one person, $1 million for injury and death of two persons, $200,000 for property, and $1.2 million combined single limit. Transporting oil, hazardous materials, or waste, combined single limit of $1 million. Transporting hazardous substances, compressed gas, liquefied compressed gas, or cargo tanks, portable tanks, or hopper-type style with a capacity excess of 3,500 water gallon, or transporting Division 1.1, 1.2, or 1.3 explosive, poison gas, or highway route control qualification of radioactive materials with a combined single limit of $5 million. Now, information for transporting hazardous materials or waste can be obtained from the Department of Toxic Substance Control, or DTSC, and CHP. Note: not all coverage requirements are listed in this section. For questions related to liability insurance for motor vehicle carriers, call DMV Motor Carrier Permit Operations at 916-657-8153. Financial responsibility may be maintained by one of the following: certificate of insurance, surety bond, certificate of self-insurance, motor carriers of property. Motor carriers must maintain evidence of insurance on file during the active life of the permit. Whenever DMV determines that a motor carrier certificate of insurance's surety bond has expired or has been canceled, DMV will suspend the MCP. To avoid MCP suspension, contact your insurance provider to submit valid liability coverage. Proof of FR, or financial responsibility. Drivers must show evidence of financial responsibility prior to the operation of the vehicle. Evidence is met if the vehicle displays exempt plates or is owned, leased by, or under the direction of the U.S. government. We will continue with Section 1.5 in the following video.